The goal of this presentation is to take you beyond the internal process required by Title IX when one student makes an allegation of a sexual offense against another, and to familiarize you with the criminal process when charges are filed on a state level and prosecuted by the local law enforcement agencies. At its completion, you will be versed in the differences between federal and state law as to the offenses charged, and further, it will highlight the unique challenges associated with the prosecution of sexual assault cases, specifically when the parties are known to one another and alcohol is involved. Colleges and universities that receive federal funds for financial aid are required to report crime statistics to the Department of Education by October 1st each year. Although the daily reports may be maintained and logged under the state criminal codes, it is important for reporting purposes that the campus and universities comply with the FBI's Uniform Crime Reporting Program. Sexual assault is an offense defined by the FBI's Uniform Crime Reporting Program and is broken into 4 categories: rape, fondling, incest, and statutory rape. Therefore, by definition, sexual assault is an offense that falls in one of these 4 categories. As of 2015, the definition of rape has been expanded under the summary reporting system under the UCR. Now, for mandatory reporting purposes, rape includes rape, sodomy, and object penetration. Using Virginia as an example, most states codify each as a distinct offense under its criminal code. For prosecution purposes, an individual would have to be charged with each offense for the conduct alleged. But as discussed, for reporting purposes to the Department of Education, each falls under the category of rape. As you can see from the definition of rape, all 3 acts are encompassed, as it speaks of vaginal or anal penetration by any body part or object, or oral penetration by a sex organ of another person. It is also important to note that these definitions apply regardless of the gender of the victim or the perpetrator. Lack of consent, by definition, also includes situations where the victim is unable to give consent because of a temporary or permanent mental or physical incapacity. This permanent or temporary mental incapacity includes situations where the victim is under the influence of drugs or alcohol. This is a definition that is consistent with most state codes. Additionally, physical resistance is not required on the part of the victim to demonstrate lack of consent, another factor that is also consistent with most state criminal codes. Fondling, another type of sexual assault under the UCR, is defined as the touching of the private body parts of another person for the purpose of sexual gratification without their consent. Fondling includes instances where the victim is incapable of giving consent, either because of their age or a temporary or permanent mental or physical incapacity. Either a male or a female can be a victim of fondling. The National Incident-Based Reporting System does not limit the definition of private body parts to those traditionally thought of. The definition of private body parts can go beyond the breast, crotch, and buttocks for reporting purposes. Under many state criminal codes, fondling is referred to by another term. Using Virginia again as an example, fondling falls under the aggravated sexual battery statute. Lack of consent can also be shown by the use of the victim's age or a mental or physical incapacity. The UCR also includes non-forcible sex offenses within the definition of sexual assault. Those non-forcible sex offenses are incest and statutory rape. Incest is consensual intercourse between individuals who have a familial relationship within the degrees wherein marriage is prohibited by law. These relationships would include parents and children, as well as siblings. It is also important to remember that the sex of the victim is not determinative as to whether incest occurred. Either males or females can be a victim of incest. Statutory rape is the 4th type of offense that falls under the UCR's definition of sexual assault. Statutory rape is defined as non-forcible sexual intercourse with an individual who is under the statutory age of consent. The age of consent varies by state. It is important for reporting purposes to only count victims that fit the specific state's statutory age limit. As we move beyond the UCR and its definitions, let's take a look at how the Federal Code defines the means by which sexual assaults are accomplished. Force can mean the use of a weapon, the use of such physical strength to overbear the will of the victim, or the infliction of physical harm sufficient to compel submission. Threat or intimidation can refer to a communication or action of sufficient consequence to induce reasonable fear in the victim that they will be the subject of a wrongful act. Whereas the definition of force or threat refers to actions of the perpetrator, mental or physical incapacity refers to the condition of the victim at the time of the sexual act, a condition that prevents legal consent. If the victim is impaired by any drug or intoxicant, and that condition is known or reasonably should have been known to the perpetrator, then a crime has been committed. If the victim is suffering a mental disease, defect, or physical disability, and that condition is known or reasonably should have been known to the perpetrator, then a crime has been committed. Lastly, if the victim is unaware that the sexual act has occurred because of being asleep or unconscious, then a crime has been committed. Although the federal definition of force or threat or mental or physical incapacity may be similar to the laws of your state, it is important to consult and review the criminal code of your jurisdiction. Further, it's important to consult and collaborate with the local prosecutor, both during the investigation and when making charging decisions. When you and the prosecutor work as a team, you create the strongest prosecution case possible. Once the investigation is done, and a charging decision has been made, and a defendant has been served with indictments, a case file sits on the desk of a prosecutor. And where does the prosecutor begin to prepare the case for trial? Although there may be detailed reports, maybe even scientific evidence, her most important witness is always going to be the victim. The victim is the person who she is most concerned about preparing for her day in court. And who is she? Who does a jury expect her to be? Is she the character in a Hollywood movie? Webster's dictionary defines victim in 3 ways: as a person who has been attacked, injured, robbed, or killed by someone else, a person who is cheated or fooled by someone else, or someone or something that is harmed by an unpleasant event, such as an illness or an accident. The word raped or sexual assault isn't even mentioned. Why is that? Ultimately, the prosecution's goal is to break down stereotypes that jurors may have regarding who or what a rape victim is supposed to be like, and for them to see her as she really is, someone that is relatable to them, a friend, a sorority sister, the college student. Aside from victim stereotypes that jurors may harbor, there are other factual challenges involved in the prosecution of sexual assault cases. These challenges are not unique to the world of sexual assault prosecution, but may be more prevalent and pronounced in a campus setting. In the general population, the majority of sexual assaults are committed by individuals who are known to the victim, non-strangers. The same is true in the campus setting. Individuals may have had a prior sexual relationship. The victim may have ingested alcohol or drugs and been under the influence of them at the time that the incident occurred. Further, jurors may have expectations of how they believe a real rape victim would respond to the trauma that had been inflicted. These challenges are not fatal, however. They can be overcome. They can be overcome through the use of laws in place and education, educating the fact finder that drug or alcohol use is not a negative to be considered against the victim, but recognized as a tool of the perpetrator. Rape shield laws limit the defense ability to introduce evidence or question the victim regarding past sexual conduct. The Violence Against Women Act of 1994 created a federal rape shield law. These laws exist in almost all jurisdictions in the United States and vary according to scope. Using the Virginia Code as an example of what is and isn't permissible under rape shield laws, general reputation or opinion evidence regarding the victim's chastity or prior sexual conduct is not allowed. What does this mean at trial? It means that a witness is not allowed to take the stand and say that he heard this about the victim, or that he heard that the victim slept with Joe Smith prior to the sexual assault. The code section reads shall, meaning that if this is violated during trial, a mistrial will likely result. There are exceptions to this rule. One is when three circumstances exist: that the evidence is being presented as an alternative explanation for physical evidence that is introduced by the prosecution. This evidence is limited to the presence of semen, pregnancy, disease, or physical injury to the victim's intimate parts. For example, if findings of injuries are made in a forensic nurse exam, and the victim's history indicates she engaged in consensual sex within 72 hours of the incident, the defense attorney has the ability to question regarding that sex and whether it could have potentially caused the injuries found. The second exception deals with the victim's prior sexual contact with the defendant. Again, this type of evidence is generally not allowed. However, when the defendant employs the defense of consent, the prior relationship is deemed relevant to negate the fact that the sex act occurred unlawfully, either through the use of force, threats, or intimidation, or through the use of the complaining witness's mental incapacity or physical helplessness. Courts are required to find that the prior sexual conduct that is deemed consensual occurred at a time that is reasonably close to the offense charged. Consent is an affirmative defense. What does this mean? It means that it is incumbent upon the defendant, if he wishes to utilize it, to present the evidence himself, either eliciting it at some point during the prosecution's case or presenting it as affirmative evidence through his own. The second hurdle is drug or alcohol use by the victim at the time of the incident. The goal in overcoming this is educating the fact finder. Educating the fact finder to realize that the use of these substances is not a negative factor to be held against the victim, but to recognize it as a weapon of the defendant in order to facilitate the crime. The education process begins by first focusing on the victim and assessing her level of intoxication. Why begin here? Establishing the condition of the victim is the first step in laying out the prosecution's theory of its case, that the victim was mentally or physically incapacitated and that the defendant reasonably should have known that. Let's take a look at the factors. How much alcohol or drugs was ingested? What type was being used? Where did the consumption occur, and over what time period? Did the victim eat? What was the victim's weight? Was she conscious or did she black out? These factors establish her level of incapacity. The next questions: did she vomit? Was she stumbling? Was she knocking things over? Was she incapable of completing a sentence? Would a person who vomited, would a person who could not walk, and would a person who is incapable of completing a sentence be able to consent to a sex act? The answer is no. After establishing the victim's level of incapacity, the next question to ask is, how did she get in that condition? What role did the defendant play, if any? Who is he? Is he the stranger that we read about? In reality, he is the non-stranger. He is familiar. He is the person that is allowed to get close. And in a sexual assault prosecution, the focus should be on him and his actions. Focusing on the offender puts the offender's state of mind in the forefront of the prosecution's case. It allows the fact finder to put himself in the offender's shoes. What was he thinking? Why did he choose the victim? Was she alone and shy at a party? Did he befriend her, give her attention, and give her compliments? Did he flirt, give her alcohol, and create circumstances that she may be embarrassed to admit following the attack? In addition to the state of mind, the offender's actions must also be examined. Did he get drunk? Was he drinking at all? Or did he just give drinks to the victim? Did he control and isolate her by suggesting they go somewhere more quiet to talk, or offer her a walk or a ride home? What grooming went on to instill her trust in him and to allow him to create the opportunity to commit the crime? We've come full circle at this point in the preparation of the prosecution's theory of the case. We've discussed establishing an identity for the victim and shown how the incapacity might have occurred. Offender-focused prosecution highlights the defendant's state of mind and actions, helping to identify him as the predator. Now we turn back to the victim and ways to bolster her credibility as we prepare the case for trial. Credibility is the quality of being trusted and believed. In an alcohol-facilitated sexual assault, the victims may be tested. She may not want to admit embarrassing facts. She may lack clear details of time and place, and her recall may be fragmented. She must be reassured that these perceived negatives are okay in the grander scheme of the case. Admitting how much she had to drink and over what period of time is important to establish her incapacity. And doesn't it make sense that an impaired and incapacitated individual would have problems recalling time and space, and that their memory would be fragmented? Encouraging her to embrace these perceived negatives will create a cloak of credibility around her. Embracing perceived negative facts will also make the victim more relatable to the fact finder. Help the fact finder understand why the victim became a target of the defendants. Jurors believe people that they like. The relatability of the victim will help negate the judgment in the minds of the fact finder. Judgment that she perhaps assumed the risk by her own behavior and realize that the responsibility lies squarely with the predator. The victim's credibility should also be bolstered by compiling as much external corroborative evidence as possible. The corroborative evidence can sometimes help fill in the blanks of the victim's fragmented recollection. Is there physical or medical evidence to corroborate the facts of the offense itself? Who did the victim make her initial outcry to? Who is the recent complaint witness? Did friends of the defendant and victim see similar things? Is there a third-party eyewitness, perhaps a bartender, who can testify about how many drinks the defendant bought the victim? And can he testify to the change in her demeanor and behavior through the course of the evening? Or are there surveillance tapes of the scene, showing the victim's condition upon arrival and the deterioration of it as she exits the scene? Or does the defendant make assertions within his own statements to law enforcement that are undermined by the other witnesses or physical evidence in the case? Now, having reviewed your evidence and selected an offender-focused theory of prosecution for your case, it's time to take the case to trial. The trial starts with jury selection, which is called voir dire. Voir dire consists of questioning. The questioning of prospective jurors by both the prosecuting and defense attorneys. Following questioning, each side is allowed to exercise a set number of strikes. These are called preemptory strikes, and no stated purpose must be given for eliminating the prospective juror from the pool. There are also strikes for cause. For example, If a prospective juror has a physical disability which would prevent him from serving, or if the juror articulates that he will be unable to follow the law in the case in coming to a decision, he can be struck for cause. The textbook purpose for voir dire is the selection of a fair and impartial jury for each side. The unspoken purpose of voir dire is to select jurors who are objective, but also open to the prosecution's theory of the case. The prosecutor should present herself as the purveyor of truth, revealing both good and bad facts. By revealing both the positive and negative facts of the case, the prosecutor will successfully lay the foundation for its theory in the minds of the prospective jurors. Although jurors may not articulate a response to a specific question, observation of them may reveal subconscious responses, indicating hidden biases. Determining witness order is very much like drafting a play. There is a compelling story to be told, that of a violent offense that has been committed. Therefore, there must be a beginning, a climax, and a denouement, a resolution. The victim's testimony is the climax of the case. With that in mind, chronological order may not be the best order in which to take your witnesses. Start by calling witnesses that the victim made her initial report to. Hearing about her and presenting some facts of the incident will create an expectation of credibility even before she takes the stand to tell her story. Following the victim's testimony, support it by next presenting witnesses who can present physical and scientific evidence that corroborates the incident she has described. In this way, the victim's testimony is surrounded by a bubble of corroboration. The prosecutor's rapport with the victim is a key factor in a successful case. The prosecutor must offer the victim her support. This support can be achieved with the assistance of a victim witness advocate. The prosecutor must also convey to the victim that she will protect her in the courtroom to the best of her ability, and not let her be subjected to unwarranted and unfair attacks. Lastly, the prosecutor must prepare her for what to expect when the case comes to trial. There are many goals for the victim's direct examination, the first of which is to introduce the victim to the jurors, to personalize her, to make her relatable, so that the jurors understand who she is and why she made the choices that she made at the time that the incident occurred. In this way, she will go beyond being someone that something happened to. Next, the victim must convey the facts of the offense. Although it is her story, the questions are offender-focused. What was the defendant doing to create the perception that the victim had of him? What did the defendant do to gain the victim's trust? How did the defendant exploit that trust? What actions did the defendant take to set off the alarms in the victim that she may be in danger? This will allow the prosecutor to argue that once he revealed himself and his true intentions, the non-stranger became a stranger when he committed the offense. In order to create a rapport and to achieve the stated goals on direct examination, the prosecutor and the victim must prepare. The tone of a direct examination should be conversational. This can only be accomplished if the parties have a comfort level with one another. The prosecutor should meet regularly with the victim, with different goals for each session. The initial meeting should take place shortly after the offense has occurred. At this time, no facts of the case should be discussed. Rather, this is a session to get to know one another, get to know the victim personally. Also review the criminal process and answer any questions that the victim may have regarding how the case will unfold. Lastly, a victim witness advocate should be present and available to discuss services that are available to the victim. The second meeting is a working meeting. At this time, the prosecutor should discuss the details of the offense with the victim, discuss any inconsistencies within statements made to law enforcement or to forensic nurses, and also to discuss anything the victim has remembered since the incident occurred. Although listed as the third meeting, several meetings may have taken place between the prosecutor and the victim prior to bringing her into the courtroom. There are several advantages to exposing the victim to the courtroom prior to the actual trial date. She can get a sense of her surroundings, and she can sit in the witness box and respond to questions for the very first time. It is also advantageous to conduct a practice cross-examination. Who should play the role of the defense attorney for the practice cross? It is helpful if it is an individual who has a style that is similar to the actual defense attorney in the case. It is also helpful to have mock jurors present. I oftentimes use staff members who are not familiar with the case. This will allow the victim to become more comfortable telling her story in front of individuals that she has never met before. This exercise should only be conducted once. To do it over and over again will create a rehearsed feeling to the victim's testimony. The fourth or final meeting should take place a few days prior to the actual trial date. No work is done at this time. It is just a means by which to touch base with the victim, see how she's doing emotionally, and give her a sense of reassurance that everything will go okay when the case comes to trial. Some final tips for the victim and other witnesses when they are on cross-examination is to listen carefully to the question that is being asked of them, and to answer it. To not argue with the defense attorney or to take a defensive tone, and to reassure them that saying "I don't know," "I don't remember," or "I don't understand" are perfectly acceptable responses. You don't want your victim or any other witness to guess or speculate to an answer when they are on cross-examination. The stated goal at the beginning of this presentation was to take the viewer beyond the college campus and to familiarize them with the prosecutorial process when charges are handled by local law enforcement agencies. We have discussed differences between the federal and state laws and highlighted challenges that are unique to the non-stranger, alcohol-facilitated sexual assault cases that are dominant in a college setting.